Good evening. My name is Alison Fisher and I work in the life insurance team at Avant. Thank you for joining us this evening to look at estate planning and the role that life insurance can play in a well thought out estate planning strategy. Life insurance covers not just life insurance or death cover, but it also covers disability cover, critical illness and income protection. Tonight, however, when we talk about insurance, we'll just specifically be referring to death cover or life insurance because that is the most relevant from an estate planning point of view. It's a topic that's not very well understood by the general population, so hopefully after this, you'll have a good base knowledge about it and feel well equipped so that when it comes time to have those conversations, you'll be able to make good decisions and you'll be able to have those conversations about insurance and estate planning. And you'll consider things that the vast majority of people just are not aware of going into these conversations. This evening, you're going to hear from myself and Brendan Crone and Michael Mobley. Brendan and I are from Avant Life. We're both financial advisors who specialise in life insurances. Brendan has over 20 years of experience in the insurance advice space, and I have over 15 in both holistic and the insurance advice space. And in Australia, there's about 250 advisors who specialise in that, and Brendan and I are two of them. Michael is a special counsel with Avant Law. He's been a solicitor for over 10 years and is an accredited specialist in New South Wales for wills and estate, and only about 150 lawyers have that accreditation. So when you consider that we work together at Avant and specialise in doctors and medical professionals, we really are about as niche as it gets from our respective fields and in a really good position to be able to collaboratively provide effective advice on the exact topics that we're talking about tonight. We'd like to begin by acknowledging the traditional custodians of the land. I'm currently in the land of the Awabakal people, and we'd like to pay our respects to traditional elders, past, present, and emerging from wherever you are at the moment. Please have a read of this important information, and I want to make sure that you know the information provided today is general advice only and may not be appropriate for you, and it most definitely does not constitute legal advice. So this evening, we're going to be focusing on 4 things. The first is what sorts of decisions you need to make in relation to estate planning. The second is getting an understanding of what sort of documents are involved. The third is where life insurance fits in, and it can actually form a really significant estate asset. And lastly, thinking about how super fits into all of that, with a focus on beneficiary nominations. So these conversations are not necessarily the easiest to have, either with your loved ones or with professionals. And I talk to doctors all the time who feel like they know nothing about these areas, but just have this vague idea that they're important and it's part of being financially responsible. So it's something that should be done. So in about 50 minutes, you'll definitely know more than nothing, and it will make these conversations just a little easier to approach. As we go through as well, please put your questions in the Q&A function, and our colleague Frank will endeavour to answer some during the presentation through that Q&A portal, and we'll also have the opportunity to go through some questions at the end. Okay, I'd say most people have come across in their personal sphere someone who has had to deal with an incredibly messy inheritance, whether it's unfair or it's complicated and goes on forever, or the family gets really nasty about it. But if estate planning is thoughtfully put into place ahead of time, it means that the right assets pass to the right people at the right time. For doctors and medical professionals as well, there's some patterns that we see in terms of the risks and what the needs are, but also everyone's circumstances are delightfully unique. Most doctors, by the end of their careers, end up having quite a significant asset base, and that brings a level of complexity with a lot of different assets and entities for tax purposes. From an income perspective as well, there's differing sources of income, and if you start a medical practice as well, there's specific risks to consider there. Our estate planning specialist, Michael Mobley from Avant Law, has seen more than a few inheritances pass hands, and where it's been done right and where it's been done wrong. Welcome, Michael. Would you like to provide some insight on this?
Yeah, thanks, Alison. Like you say, it's really easy to fall into this trap of thinking that things will just work out for us, for our family. It won't happen to me. Only for your family to later discover that's not quite true. Um, on, I guess, a more financial level, there's a lot of things that you can put in place now, but if you don't do them now, again, your family's potentially going to miss out down the track. Now, nearly half of all Australians don't have an effective estate plan in place. It's quite a large statistic. I can tell you lawyers are guilty of it too, not me, of course. But I have seen people from all walks of life be affected by failing to plan ahead. Now, those consequences can be fairly minor, right through to being forced out of a home that you've lived in for quite a long period of time. And I'll talk about one of those examples a bit later. But I guess really the key message that I want to get across now is that estate planning doesn't need to be hard. It's not as complex necessarily as it may seem on TV, but you do need to take that active step now to ensure a positive outcome for those around you. So if we can move to the next slide, I just want to walk through the types of things we're talking about when we say estate plan, because often when we say, oh, I'm doing my estate planning, many people just assume it's a will. You know, it's something when I pass away, it's a document. And if you believe what's on TV, you might have all the family come around and have it read out to them by a lawyer. Not something we do, but great on TV. But it's more than just a will. There's lots of different documents, whether it's a will, a power of attorney, an enduring guardian. We also have other items like life insurance policies and super death benefits. Now, all of these are really important, but if we can move to the next slide, I just want to kind of highlight the power that comes from these when we put them together into a cohesive strategy. Because having just one is often not enough. We need to kind of have that broad coverage where every part works in sync and ultimately becomes our estate plan. So those things combined are what we're talking about when we say estate planning. Now, there's two things that we're doing here when we make our estate plan. The first one is taking care of our future. So whether that's passing away or needing someone else to step in to look after you should you lose capacity, but it's also to protect those around us. So whether that's making sure your household runs in your absence, or just minimizing the effect of taxes and duties, your estate plan can do a lot more than figure out who's getting the gold necklace or the stamp duty, the stamp collection, I should say, if you pass away. But it is something we need to do now, as soon as we're adults, rather than later. Of course, we hope for the best. We hope those things don't happen to us in the future, but they do happen. I've had clients as young as 18. I've had clients as old as 103. It can happen young or old, rich or poor, family or no. Uh, Estate planning really is for everyone. But not everything can be covered just by making a will. There are some things you have to do even outside these documents. And that's where I'd like to go to the next slide, please. Just to kind of highlight, I guess, the difference between the types of assets we're talking about. One of the common traps I see when I meet people in a meeting is for them to say, I want to leave everything to my family. Can I just write that in my will? Or I'd like to give my super to my spouse. I'll just write that in my will. Unfortunately, not that simple. So estate assets, things we own in our own name, they're things we can give away directly in a will. So for example, if I have a car, I can say in my will, I give my car to my next door neighbour. It's mine. I have the legal right to do it, and that's effective under a will. But by contrast, the super example, we can't give it away because technically our super is held by the super fund on our behalf. It's not enough just to say I give the super. We need to take an extra step. And for that, it's a death benefit nomination, which you might have come across before. Each fund does it a little bit differently, but you need to take that extra step to actually make it work. Now, of course, this is just a very broad overview. Having a good team assist you with your estate plan and bringing all these things together, plus taxes and financial planning, that's going to put you in the best position to get an effective plan. So I might pass to Brendan just about how he deals with life insurance and super in this space.
Thanks very much, Michael. Okay, so the role of life insurance as part of estate planning. There's many reasons you'd consider insurance as part of your estate plan. I'll just go through a few of the main ones. Firstly, and most obviously, it can provide financial security to your family and your loved ones, especially if you're at a point in life when you haven't really built up significant assets, or you may have or thinking of taking on significant debt to buy a house or invest in a medical practice or whatever it is. Secondly, life insurance is an established way to equalise inheritances. What do I mean by that? You might want to give one beneficiary a holiday house, but not have much left for another one. You could use insurance to equalise the score so they both get something. Thirdly, you may be a shareholder in a business with some medical colleagues. If you exit the business due to death, life insurance can provide the funding mechanism to basically pay out your share of the business. To ensure your estate receives its due considerations for the share value, and your surviving business partners get a clean break and don't otherwise inadvertently end up in business practice with your family who might not have the interest or the inclination to do so, to run a medical practice. Fourthly, charitable reasons. You could use it to fund a bequest to your favourite charity out of a good cause. And lastly, let's just talk about liquidity. This is an important asset considering if your other assets you're going to bequeath are lumpy. What do we mean by lumpy? Things like real estate, certain share portfolios, or certain other types of assets that really are difficult to liquidate in a timely manner. Or assets you possibly want to keep in the family for sentimental reasons. A life insurance policy can provide almost immediate liquidity to fund things like estate taxes, funeral expenses, and generally pay the bills at home, keep the lights on for the family. After deciding when the insurance is appropriate, you also want to then move on to consider how much is appropriate. This can be quite a complicated calculation, but an experienced advisor such as Alison and myself, we go through a process to come to a pretty well matched requirement that suits your needs. I mean, every person is different. Every person is in a unique position with different circumstances and goals. So I'll go through a few of the factors we look at when we're working out what we call a needs analysis to suit you. The main one is the future income foregone upon your death. I mean, you obviously realize your family or your loved ones possibly rely on your income. If you pass away, their ability to pay for things such as rent, mortgage, education, groceries, etc., etc. I mean, how would they do this? We look at a net present value of a lump sum amount, which basically substitutes your foregone income, which they can use to help fund these expenses. We consider your debt, which is obviously a huge consideration. You might have mortgages, investment debts. You might want them paid out upon death. We consider that. Your children, their private schooling, tuition, extracurricular activities, not cheap. We consider things like that. We consider resources available to offset the insurance need. You might have significant savings. You might have assets you can liquidate easily. You might have a large superannuation balance. We look at all those things. And of course, the list goes on, is quite exhaustive, but we can't really go through every situation. That's just some of the key points. But in the next slide, I'll pass over to Alison to cover off some of the typical inflection points that people may go through that trigger a need to review their estate planning and life insurances. Thanks, Alison.
Thanks, Brendan. So to put those needs into context of where you are at in life, you can see your career stages along this line here. And how much insurance you need will also depend on what stage you're at in life. So today we're focusing on the life insurance only aspect and how that gets passed on, but there are other personal insurances that may be appropriate along the way too, of course. So typically at the start of your career, you'll have finished uni and start earning an income, and then perhaps you start accruing debt and you buy your first place. Then after that, maybe your family grows and you pick up a few financial dependents. Then you might look at buying a bigger family home so that you can accommodate those extra financial dependents and increasing your mortgage amount to accommodate that as well. And maybe you start looking at investment properties there and the associated debt there too. At this point, your income is likely to be quite high once you've moved through those stages, being a registrar, perhaps completing a fellowship and becoming a consultant. And from a risk perspective, you may want to look at whether your financial dependents would be okay if anything happened to you. And then if you start a practice or take over a business, you may also have some associated business risk. And sometimes the dependents, the house, and the income and the practice all happen in quite quick succession as well. And this is where insurance needs typically peak. Then, by the time you're ready to retire, you're able to self-insure, because at this point, you would hope that your asset base is sufficient to support any lifestyle and other expenses forever after. So between peak needs and retirement, there should be a tapering. So it may be appropriate in this period to reduce or even cancel cover and look at what levers are in place that you can pull to make it more affordable if it starts getting too expensive. I've been in advice for a while now, but when I was starting out, my very first clients were at the peak stage. They were a couple who owned a business together. They had debt, they had a young family. And as part of their planning, we put in place risk strategies and had the what if conversations. Subsequently, the husband passed away actually relatively soon after that, and it was devastating for the family. But what I got to witness firsthand was how incredible it was that because we'd had these conversations previously, she was able to settle her debts, exit the business, and relocate closer to her family so that they could help support her with the kids. And to have the financial freedom to be able to do that in those circumstances was really powerful. So I'm thankful to say that not too many of my clients over the years have had to claim, but when they have, it's made a meaningful difference in their lives. So Michael, from your perspective, there's different life stages where estate planning becomes very pertinent too.
Yeah, definitely. I think it's probably worth saying from the outset, the short answer is going to be every stage is important for estate planning. And the reason why is this, because often we look at that stage of buying a house or starting a family as probably about the right time to make a will. Certainly, if I ask my own parents, that's kind of the time that they thought to do those things when they were younger. But we really need to be considering it at all stages. So if we look back at that starting position there, we've got somebody young sitting there relaxing under the sun. They're technically an adult. Mum and dad might treat them a little bit differently, but they are technically an adult. If we lose capacity, who's going to step in? Now, it's not common, but I have had cases with 18-year-olds losing capacity suddenly, whether due to accidents or mental health reasons. Mums and dads often do think, okay, I've looked after my child for a long time, I can step in. I'm the natural person to step in and do this. The truth is, though, you can't. As an adult, they're no longer under your guardianship. We need something more to get them looked after by you. And that's where a power of attorney document comes into play. So certainly whilst they're alive, we do need to think about documents both for ourselves and for our younger children. But think also about super and other items that your child might have. Now, they might not have been working particularly long, but often younger people, when they enter super, will get default insurance policies. Perhaps they will pay out as well. Parents, again, often assume they're going to inherit that super without anybody else around. But technically, super can't pass to parents just purely by being a parent. We have to do a bit more. And a will and other documents are the way to resolve that. Now, of course, we move into that middle stage of starting a family, buying a house, the more traditional reasons for putting a plan in place. And I think most of us would agree that there are important things to protect at that stage. So commonly, that's where I'll see most clients making their documents, but I, again, encourage anybody prior to that time to make one as well if they don't have one. And then lastly, as we move into later stages, perhaps we're not so much looking at the care of our direct children. We might now be thinking about the future and what it looks like for our children's children. And so again, estate planning can really help with that stage. So I guess probably one thing to highlight is that we do try as much as possible to future-proof in our documents. We don't know what's coming up ahead. And estate planning is not static. It's really not something we should just do once and forget. we need to adjust it for changes in our life. So if we can move to the next slide, I'll probably pass back to Alison to talk more about how life insurance is held, just so that we can explore that a bit further.
Thanks, Michael. So as you touched on earlier, life insurance can be an estate asset or not an estate asset. So understanding how it's owned is really important as it affects how and to who it flows. So with life insurance, there's actually 3 people or entities involved. The person who is insured or the life insured can be different to the owner, and then the beneficiary is obviously different as the life insured isn't around to be paid. So to clarify, the life insured is the person who, if they die, then an insurance benefit is paid out. The owner is who's responsible for paying the premiums and choosing who receives the benefit. There's different tax implications for the owner of the policy depending on which type of entity owns it and pays for it as well. And then the beneficiary is the person or entity who would receive the benefit. And you can nominate pretty much anyone, family members, friends, organisations, businesses, but a really common one is nominating your estate so that it's dealt with in accordance with your will. So for me, I have a life insurance policy, surprise, surprise, being a life insurance advisor, and I'm the life insured on that policy. So I also hold it through superannuation. So my super fund is the owner of the policy, and the premiums are paid through superannuation. And if I pass away, the beneficiary is ultimately my estate, which will flow through as my will dictates, which is to my family, and so on and so forth. So as you can see on this slide, there's a lot of options for ownership, and we'll go through these. So the solely owned is personal ownership, and it allows you to nominate any beneficiary without a restriction. The proceeds can go directly to the beneficiary or to your estate, and the beneficiary can also be the policy owner or another person or entity entirely different. Jointly owned isn't very commonly seen now, but it functions as per any jointly owned asset. Superannuation I'll skip over and Brendan will come back to. And then family trusts can also own insurance policies, often on behalf of a family. It isn't common, but it may be set up if the family want total discretion on how the proceeds are distributed. It's certainly an area for specialist advice, including around tax as well. So we'd definitely be talking to accountants and lawyers regarding that one. And then the company as well, you can have companies as both the owner and the beneficiary of policies to make sure that if there's funds needed in a business, you can cover risks such as company debt or equity, or if a key person has to involuntarily exit, that can be covered too. So we work in conjunction with your accountant and lawyer to make sure that it's tax effective and that it's underpinned by the appropriate legal documents. The end goal is to get the funds where they're needed in the most tax effective manner and get the funds to the dining room table that need to go to the family and to the boardroom table that need to go to the business. It can get pretty complex. You can see there's different options, but very commonly it is directed to the estate so that it can be tax effectively dealt with. Brendan, so let's go back to superannuation, and there's definitely advantages to holding insurance policies in super. Can you please shed some light on this?
Sure, definitely. Let's talk a little bit about the advantages of holding a life cover within superannuation. Firstly, foremost, most people do it for the cash flow aspect. Rather than pay for the cover out of pocket in after-tax dollars, you can have your superannuation fund pay for the cover via a behind-the-scenes annual rollover with funds that you've contributed to super. Your super balance is sitting there. You can't access it to age 67 or you meet a condition of release. It may as well come in and do something handy like covering the cost of the life insurance. Of course, this will deplete your super balance. However, that can be remedied potentially with extra super contributions subject to superannuation caps. On super, contributions are generally taxed at 15%, which is going to be a lot lower than your marginal tax rate, which for high income earners is 48.5%. So there's a bit of a freebie tax advantage to utilise there. I mean, life cover is pretty straightforward. There's no tweaks or bells and whistles to it, such as other cover like total permanent disability and income protection. So holding it within super, you're not foregoing any loss of benefits. It's just simple life cover. If you do pass away, this does meet a condition of release of your super balance. So the funds won't be held up in the super environment, but will be released. You are able to nominate someone as a beneficiary within your super. There's what's called a superannuation beneficiary, usually a spouse, a child, or you could even nominate your estate, in which case it will go through your will. As long as the beneficiary is also what's known as a tax beneficiary, which is slightly different to a super beneficiary, the death benefit will be tax-free. However, if left to a non-tax beneficiary, such as an adult child, there can be tax implications. Just on that, just be aware of issues which could arise if you have no nominated beneficiary in your super fund or pension plan. A case in point, a real life story of a grandmother that passed away. She had 2 daughters. Initially, she only wanted to leave all her assets in her will to one daughter and cut the other one out altogether, but was advised, don't do this. The other daughter missing out will challenge it. So she changed it to 80-20. This is through her will. It was current and valid. When she passed, the will assets went 80-20. However, she also had a very large pension plan with no beneficiary listed. So because it's a non-estate asset, it did not go through her will. The deciding factor was the superannuation trustees who looked at her situation, saw 2 daughters, distributed the pension assets 50-50, which was far from her wishes. In the end, the overall outcome was quite different to her original plan of 100 and 0. This could have been remedied by just having a simple, valid, current superannuation beneficiary, or the beneficiary nominated being her estate. So just some areas of concern to be aware of. And just to speak further on making sure that your assets are set up so that they flow to the right beneficiaries, I'll hand back to Michael, our estate planning lawyer, for an overview on our key legal documents you need to have in order. So over to you, Michael.
Thanks, Brendan. If we can move to the next slide there. Yeah, perfect. So we've talked a lot about wills, and I guess I probably just want to focus now on what actually is a will. It's easy to say, perhaps harder to pin down. But in short, it's a legally binding way of outlining our wishes. It's making sure our assets get to those people we care about and putting the right people in charge to make sure that actually happens. Now, wills can be deceptively simple. You can pack them with additional features, but ultimately they are unique to us. A will that works for me is not necessarily going to work for you. And certainly I wouldn't encourage you copying somebody else's directly. It needs to be prepared for our individual circumstances to make sure the right outcome can occur. And as we've seen along the way so far, things like ownership of assets, how we hold our policies, all those types of things factor into what often looks like a straightforward will document. They can help us protect against undesirable or unintended consequences, which I'll dive into in a minute. But they can, like I say, have those additional benefits. So if we do have something like a testamentary trust will, we can build in features like income streaming, asset protection, many of the things that you might find in a family trust that you have during your lifetime. We can do that and even a bit more if we set it up via your will. So that's all the good side, but I wouldn't be a very good lawyer if I didn't highlight the bad side, and that's why I want to move to the next slide now, which is what happens when someone dies without a will. Now, I'm very passionate about getting everybody at least one will in their lifetime, even if they're 18, because of the things that can happen here. So when someone dies without a will, we often call it dying intestate, or intestacy, you might hear it called. So the rules of intestacy set out who gets what when there's no will, and it's a very blunt instrument. I cannot stress enough how blunt it is, because depending on the circumstances around your death, what you think may happen can end up quickly being something else. So to give some examples, I previously helped an estate where a person died without a will, and their siblings thought they would receive everything because they had not seen their biological parents for a long time. They were estranged. Based on age, they assumed they had passed away. Now, it turns out with some digging, which we were required to do because there was no will, we had to see who the next of kin was. Turned out the parents were alive, at least at the relevant time. So the parents inherited, but before the money actually got to them, they themselves passed away as well. So now not only has the inheritance skipped the sibling who thought they were inheriting, but it's actually skipped the parents as well because it's now gone via their wills to people that the surviving sibling had never met. Now, we were able to negotiate an outcome with those parties, but it could have been a lot worse. Legally, the sibling had no entitlement to that money in that situation. With a will, the deceased sibling could have avoided all this by just leaving his parents out and giving everything to his sibling. In another matter, I helped some adult children with their late mother's estate. Now, she had a will. She'd been married a couple of times, but the kids were quite confident that she had divorced. They hadn't been together for a long time. They weren't using the same name. They'd had conversations around divorce while she was alive. But on further investigation, it actually hadn't gone through. The mother hadn't done that final step. So technically, the husband was still alive and he was still husband. Now, under intestacy, a husband or a wife is entitled to a portion of the estate purely by being married. So it doesn't matter how good or how bad that relationship is, just by meeting that criteria, they were entitled. So all of a sudden, what we thought would be divided amongst 3 children was now being divided amongst 4 people. And again, a will would have avoided all this. It didn't need to be complicated, but the fact that we didn't have one, the law said this is the way it must play out. And this will repeat time and time again when there is no will. So if you have something like joint assets, so often couples will have a joint home, where that property goes after both of those people have passed away will depend on that survivor's will. Now, if they don't have a will, it will flow to their next of kin. And next of kin means biological next of kin. So if I've got nieces and nephews on my side of the family and my wife's side of the family, we're only talking about mine if I'm the survivor. Again, a very blunt instrument. You can imagine scenarios where couples pass away in a car accident or a plane crash. Very quickly, that can spiral out of control. Not so if we have a will. Because a will can protect your estate by making those intentions clear and saying what you want. And that can even be to exclude somebody as well. So I'm sure a lot of people have seen either in the news or perhaps somebody you know, wills being contested, leaving someone out. Now, a piece of paper is not going to be able to stop a person from making a claim, but it can definitely go a long way to protecting the estate. Even if someone's successful, they're not necessarily going to be as successful as if you hadn't made a will, because often people will say, you didn't make a will, you just forgot to do it. You would have given me something if you had. Making that will is a deliberate choice to highlight that you have left someone out. So if you do come across that situation, there are things you can do within your will to help protect your estate. Now, all that's a bit doom and gloom when somebody's passed away, but it is only one part of estate planning. And so when we're alive, what can estate planning do for us then? Because remember, going back to that earlier slide, it's not just a will, it's all these other documents coming together as well. So if we move to the next slide, that's where our power of attorney document comes in. And it's a really powerful document. You've probably, if you've got older parents or perhaps during practice, you would have seen these perhaps for patients where somebody else is making the legal and financial decisions for that person. Now, often we assume this is when we can't make decisions on our own, and that's very true. But it's not just those circumstances. So for example, if I go overseas, I might still be capable of doing those things myself, but I might want someone else to go bid on a property at auction for me, or perhaps sign some documents, go to the bank and take some money out. If we've got elderly parents, again, they might be very capable, but perhaps they don't want to, or physically they're unable to go do those things themselves. And so we're able to delegate those powers to someone else. Now, it is a very broad power. It's really probably the most powerful permission slip you'll ever make, because it allows that person to act as if they're you. They stand in your shoes. If they come to see someone like a lawyer, like an accountant, that person can be treated in the same way that you are treated without having any extra checks and balances. And so that could be things like buying and selling property, paying bills, signing contracts. Really 95, 97% of the things you do, they can do as well, with some exceptions like not being able to change your will. Now, that of course can also extend into business structures and other assets as well. But I really want to emphasize that those types of things like businesses, it's not as straightforward as saying I've got a power of attorney, it covers everything. There are additional rules in place that you need to be really careful of. And again, depending on which state you're in as well. So don't risk it if you're trying to cover any of those things. Have a lawyer prepare that document to make sure it works properly. It's one of the best investments you'll make, because when you need it, you really need it. Without one, there is no one capable of making those decisions for you. You have to go to a court or tribunal, doesn't matter which state you're in, to get somebody to come in and take over those affairs. Now, that's slightly different to the next slide, which is about health and lifestyle decision making. And so often here, particularly if you're in a relationship, you might think, okay, well, if something happens to me, my spouse, my partner come in and take over. And that's true to a degree, depending on which state you're in. But we can do a lot more with this document. So we're not just talking about the bare minimum. There's lots of extra features we can do to make this arrangement really work for you. So essentially a guardian or a substitute decision maker is there for when you can't make decisions about your health or lifestyle. And that could be things like deciding where you live, the doctors you see, medicines you take, whether or not you have surgery. We can even dive into things like end-of-life care. So things like palliative care, CPR, we can address those things in a guardian document. And again, whilst there are some limits, so for example, we can't do voluntary assisted dying via a guardian, that's a separate consideration. Pretty much everything else is on the table. So it is a very powerful document for when you can't make that decision yourself. So why would you make one if you already by default had a husband, wife, partner, spouse who might be able to step in for you? And my answer to that is simple. You can control exactly how that appointment operates. So take, for example, if you are in a relationship and you have 3 children. Now you might decide, okay, if something happens to me, my spouse will step in. But what if you're both out of action? How does that work? Which child takes preference? Who gets what say? Will they work together or will they try to work against each other? All those things you can outline in your document. You can say, for example, I want majority decision making, or I want all 3 of those children working together. Or perhaps if you've got people moving overseas, you might come up with some other arrangements so that everyone's still involved, but perhaps not so restrictive. So a lot of things to consider in that document. But again, I really encourage you to think about those 3 documents if you haven't got those in place already. Now, I appreciate it's a lot of information to take in on a Wednesday night and can be very heavy hitting if you haven't come across these things before. So it probably is helpful to bring that all back just to some key points that you can take away today. So Alison, if we can go to the next slide, would you be able to walk us through just some of those points that we've covered off so far?
Sure. So if we can call out the key actions out of all of that information that we've had, it would be these 3 things. The first is think about where you want things to go when you pass away. The second is if you have an estate plan in place, just revisit it, make sure it's in line with what you currently want. And if you don't have an estate plan in place, it's obviously time to start having the conversation. And thirdly, if you have life insurance in place, whether it's inside or outside of super, have a look at it for the amount and the beneficiary. And they're really the 2 most important things to look at here. Lastly, don't put it off. As tricky as the conversations can be to have, make sure you get it sorted now so that you don't leave behind a messy situation for your loved ones. At Avant, Avant Life and Avant Law obviously cover more than just estate planning. As I said at the start, life insurance is more than just death cover. We also include things like lump sum covers if you're permanently disabled, income protection for temporary or permanent illness, and critical illness cover. Avant Life can recommend which of these covers are suitable for your personal circumstances, and also review their appropriateness from a business perspective as well, whether that be business overheads cover or using any of the covers to protect key persons in your business, or fund buy-sell agreements if you need to exit the business due to some unforeseen event. There's no advice fees for members, so if you'd like to get in touch either for a quick chat if you have a question or two, or you'd like to go through your situation and what risk protection may be appropriate, please do. Avant Law help with all major legal needs for both personal and business aspects as well, and for Avant members they provide a 10% discount. So now we will move to some questions. Frank is our Senior Risk and Compliance Manager, and he'll run through some of those now. Thanks, Frank.
Hi, everyone. We've certainly received some great questions tonight. I don't think we're going to be able to get through all of them, but let's give it a go. So this one is for Brendan. At what age does life insurance stop paying out usually?
Well, each policy is slightly different, but a lump sum life cover payout, the policy usually cuts out these days around the age 80, but bear in mind the cost of it by then would probably be prohibitive. Like $1 million policy might cost you $500,000 a year. Some policies keep going until death, so effectively they will pay out, but it's just a mathematical calculation. Is it worth to keep holding on to? Usually the cost becomes too prohibitive, and they all revert to a stepped premium after a certain age.
Thank you, Brendan. This one is for Alison, and it's on a similar theme, but a little bit the other way. What age should you stop buying life insurance?
I'm going to give an answer that Michael will be proud of me. I'm going to say it depends. So the answer is ultimately when you can self-insure and you can fund all of your living needs forever after. That's the ideal scenario. But in reality, as Brendan touched on just then, you're going to have periods in life where you might need some cover, but it is cost prohibitive, and then it's just working out the balance between that. So hopefully by the time you retire is when you should stop buying life insurance or paying the premiums for life insurance, but it might happen before then if you're in a really secure financial position.
Thank you, Alison. We're getting quite a few legal questions as well. So this one is for Michael, and it's around a testamentary trust. So can a testamentary trust be set up in a way that is tax effective for an overseas beneficiary? For example, an adult child who lives overseas.
Yeah, overseas beneficiaries are interesting because whilst they're our child and we want to benefit them, tax laws, particularly overseas, can be quite complex. And so we're not only dealing with Australian laws at that time, but also the other jurisdiction or potentially multiple jurisdictions, depending on how strict that tax environment is. So the only way you're really going to be able to know is to take your specific example and to have that checked by an accountant here and perhaps also in that jurisdiction overseas. I would often encourage you to think about other ways you might be able to direct that gift because a lot of the states, New South Wales in particular, are quite heavy-handed with certain assets if overseas beneficiaries can benefit. So it is possible, it's not illegal by any means, but there may be more effective ways to benefit that person than by using a testamentary trust. Contrast that though with what we can do in Australia. There's definitely a lot of benefit if you've got individuals here.
Thank you, Michael. Another one now for Brendan. Somebody's asked, how do we arrange super or pension to go to beneficiaries without a tax liability?
Okay, well, you have to ensure, number one, it's a super a super beneficiary within the SIS Regulation Act 1993. And also it's a tax beneficiary. They are slightly different, but your advisor and your accountant can help look at that because it is important to get right, else there could be tax considerations. But you have to consider the super beneficiaries and the tax beneficiaries both together.
Thank you, Brendan. The next one is for Alison. The question is, upon my death, if there was no nominated beneficiary in the policy, who will get the payout? They haven't specified whether the policy is inside or outside super in that question. Maybe you could have a go at both
Yep. So outside of superannuation, if the policy owner is also the life insured, then it would generally go to the estate, I believe, Michael, correct me if I'm wrong. And then in superannuation, it's the trustee's discretion again, and it's up to the trustee to work out who the appropriate person is. Yeah.
All right. Thank you, Alison. We're getting lots for the testamentary trust. So here's just another one, Michael. Please comment on the disbursement of actual cash distributions from a testamentary trust to minor beneficiaries. Specifically, can these be used for family household expenses, held for future education expenses, or used for the remaining parent's mortgage?
Yeah, well, the remaining mortgage is an interesting one, but certainly those initial items that you've mentioned can be. Often even a standard will allow that position to an extent. But to highlight, I guess, the real benefit for minor beneficiaries, I'll give you the example of a young family. So imagine, let's take myself, it's probably the easiest. So I'm married, I have a child who's underage, doesn't work. If I pass away, in a normal setting, I give everything to my wife, she takes it, that's the end of the story. If she invests it, makes income on it, it'll be part of her income tax. That's a standard style will. In a testamentary trust will, it's a little bit different because what she can do instead is take that money that she's inherited from me, and that might be from super or life insurance or somewhere else, and put it into a trust. And when we have that trust and we're earning income, we can distribute to various beneficiaries, including minors. So the tax office basically acknowledges the death of someone and allows us to distribute to that under 18 person as if they're an adult. So that's a very clear distinction between a testamentary trust and a standard discretionary trust. If you try to do that in your current trust, which you might use for your practice, it's only about $400 you can give before you really get hit with a major penalty. But because we're treating a minor like an adult, that's $18,000 for that child, tax-free. And you can repeat that every year indefinitely because that child, as they become an adult, again, it's still adult tax rates. If you have multiple children, that's multiple lots of tax-free thresholds that you can use. And if your spouse stops working, so let's say I've inherited that trust from my parents, so it's myself and my spouse and my child, and my spouse stops working, I can give that benefit to her as well. So we can really adjust where that income goes on a yearly basis. It's very, very flexible. But in that standard will arrangement, it just arrives lump sum in my bank account, and that's kind of as far as I can go. So a lot of things you can do in that testamentary trust space, including covering those expenses if it is a minor child.
Thanks, Michael. I've got another one here for Brendan. Does it take a long time to get a death payout from super? I've been seeing in the papers articles about people in super funds waiting unreasonably long periods of time to get death payouts.
Yes, thanks, Frank. Yes, I'm aware of that story in the paper, and those particular super funds have been punished heavily by the regulator. And that is not the norm. The norm is generally 4 to 8 weeks. It's not instant. There's still a process you have to go through, such as providing death certificates, letters of probate, which you can work through with your lawyer. But generally 4 to 8 weeks. So not instant, but nothing like those stories in the paper.
Thank you. The next one is for Alison. It says, you focused on death cover today. I imagine if I see an advisor like you, that you would also review if I need disability cover.
This person imagines correctly. So we don't just deal with death cover. We also go through the needs from more of a holistic perspective and just work out what's appropriate. And often we see total and permanent disability go hand in hand with life insurance because they can be structured so that they're held together, and it can become really cost effective to do it that way as well, especially if you're covering the same sorts of needs and you don't need 2 payouts. So yes, we'll consider everything.
Thank you. I'm still getting lots of trust questions for Michael. So I've got one here. Can our primary home be placed under this, referring to a testamentary trust? And does this have an impact of capital gains tax in case children sell the house?
Yeah, so it's probably two-pronged in there. I mean, generally speaking, when we have a primary residence and we pass away, we give it to someone else, provided it was our primary residence only. So there are circumstances where you might have rented it out, things like that. But if it's been our primary residence, you usually will have a 2-year period where you can sell that property without any concerns around capital gains tax. If it's beyond that 2-year period, you would need an extension from the ATO to have CGT not apply. Now, technically, it is allowed. So let's say both parents have passed away, we've got the family home. You can put that into the testamentary trust if you wish. So if you have more than one beneficiary, they would need to work out how that's going to be held, whether it's equal shares or perhaps one of them takes it in consideration for something else. But you can place that property in there. What I would really encourage, and this I guess perhaps goes to the broader operation of these trusts don't start whilst you're alive. So when you make a will, it sits there essentially dormant. It's not doing anything. You can change that will. It's only after your death that your children or your beneficiaries decide whether to engage various aspects of that testamentary trust. So we would often encourage those beneficiaries to talk to accountants, map it out. Is this going to be beneficial? Is it easier if it's going to be cash? And there may be other reasons why you convert that property as well. So if there is a foreign beneficiary and you want them to benefit, property is a really big red flag in terms of surcharge duty. The simple answer, sell the property. We no longer have surcharge duty. So it will depend on your individual circumstances, whether you put the property into the trust or not. But it is certainly possible under a will once those people who've held it have passed away.
Thank you, Michael. Got another one here for Brendan. The question is, if I have a large amount of death cover in my superannuation fund and I die, is any of it taxed?
Similar to the query before, it depends who the beneficiaries are, if they qualify as a tax beneficiary or not. Generally, it's things like spouse, children under the age of 18, former spouses, or financially dependent people. But it's case by case, and tax beneficiaries are slightly different to super beneficiaries, just to keep you on your toes. So it's worthwhile consulting a financial planner or lawyer to get that right, to avoid unnecessary tax.
Thank you, Brendan. One for Alison. What factors affect the cost of life insurance premiums?
Yeah, good one. So there's actuaries that work for insurance companies that their whole job is to work out exactly how the premiums are calculated. But on a broad level, generally, the older you are, the more expensive they're going to be, because the greater your risk is of passing away or having to claim on that policy. But there's a whole lot of other factors that go into it as well. So health can be one of the considerations. And generally, when you apply for retail insurance, they'll get an understanding of your health situation so that they can adequately assess that risk. And then the other thing is market factors as well. What are interest rates at? Have they had to do a lot of claims? And market factors as well. So it's quite a bit more complicated than that. I don't want to oversimplify the actuarial input into that, but generally age, health.
Thank you. I think this might be the last question for tonight, and it's for Michael, and he'll be pleased that it's not a testamentary trust. I think someone mentioned that wills can be contested. The question is, can this also apply to powers of attorney?
Yes, it can. So generally speaking, with powers of attorney and guardian, and this is why I really encourage people to make them, if you make those documents, they are enforced once the trigger event happens. So if I lose capacity, for example, my power of attorney steps in. Now, that is really rife for abuse if we don't have some kind of oversight. Because if I appoint Alison and then Alison goes off the rails a bit, we want Frank or somebody else to be able to step in and say, hey, there's a problem. So generally speaking, each state will have their own administrative tribunal that's able to intervene. So generally speaking, somebody will put their hand up and say there's a problem. The tribunal will review it and decide whether Alison gets to stay or if perhaps somebody else comes in. Now, that can also happen through the court, but it's only on review. So if you've got a document in place, you won't be going to the tribunal automatically. If you lose capacity and don't have that power of attorney, you will have to go through a tribunal or a court. And I've had teenagers in that situation where mum and dad have tried to act and they can't. And so we have to go to the tribunal. So yes, definitely can be contested, but it's not just a straightforward, I don't like it. It's very much looked at from trying to protect you as an individual, and the courts are very good at putting those things in place.
Thank you. Look, there were so many questions as well that we couldn't get through, and many of them actually went into quite specific personal situations, and obviously that means we can't really go into that sort of level of detail in the general advice situation that we are in. However, on the next slide, Alison and Michael are going to talk about the offerings that their relevant teams offer, including free personal advice that our team offers. So over to you, Alison.
Thanks, Frank. So as we mentioned, if you click those QR codes, so advice is on the left and Avant Law is on the right. That will take you through to us and you can get in touch with us. As we said, there's no advice fees. If you have a question, if you have 20, please do that. Michael, did you want to cover off on Avant Law?
Yeah, sure. I mean, there's lots of areas of Avant Law. We're not just wills and estates. We do commercial work, employment, property. But for the purpose of this discussion tonight, if you do have estate planning questions or probate or family provision, any of those things, you are welcome to make that initial appointment. There isn't a cost for that. We would walk you through step by step the types of things you might want to put in place around wills and attorneys and other things based on your circumstances. And then from there, you choose and decide how we go about setting that up for you. But costs nothing to chat, and better to chat than to sit there not sure where it's going to all go. So yeah, please reach out, book that appointment, and we can certainly help you.
Yeah, thanks, Michael. And Michael and I end up working together quite a bit because people like to have all the fun conversations at the same time often. So we'll wrap it up there. Please use the QR codes if you want to get in touch. Following this, we're going to send out our guide to estate planning, which will provide you with further information, and a recording of this will be made available as well. It's a pretty technical area. We're here to help. Thanks everyone for joining us, and we look forward to being in touch with you in the very near future. Thank you.